Hi, everyone. My name is Giza Lopez. I am the Executive Director of the New York State Youth Justice Institute. I want to start by welcoming each of you to our Lunch and Learn webinar series. We appreciate that you're making time to learn more about youth justice research and practice. Please feel free to introduce yourself in the chat if you'd like. I want to express my thanks also to all of our partners in New York State, and especially to the Division of Criminal Justice Services and UAlbany. Without their institutional support, we wouldn't be here. We here at the YJI are very excited to present to you our very first Lunch and Learn Plus today. Today's webinar is co-sponsored by the Offices of Attorneys for Children in the 3rd and 4th Judicial Departments. Director John Cragno of the 3rd Judicial Department has a couple of welcoming words to share. John, you're up.
Great. Thank you so much. I promise to be incredibly brief. As everybody or the AFCs know, my name is John Cragno. I'm the Director of the Office of Attorneys for Children in the 3rd Department. And I want to sincerely thank the New York State Youth Justice Institute for allowing us to be part of this program today. I know I speak for Deputy Director here in the 3rd Department, Cynthia Schrock, as well as our co-sponsors and colleagues in the Office of Attorneys for Children in the 4th Department, Director Linda Costa and Deputy Director Jennifer McLaren, when I say we very much appreciate the opportunity to offer this program to AFCs in both departments. For AFCs in both the 3rd and 4th departments, please note that there'll be one or more CLE verification codes that'll appear during the program. The coder codes will appear on the screen and be recited audibly. Please make note of any codes that you see or hear, as you're going to have to provide those codes in order to receive CLE credit. For those of you who registered for this program through the Office of Attorneys for Children in the 3rd Department, you received a link with a form called the Certification and Evaluation Form. This is the form that you need to use to insert the codes that you see in here today. For those viewers who registered through the 4th Department, you received a similar form for the same purpose. If you have any doubts, please reach out to the office through whom you registered for this webinar. Please also note the speaker evaluation portion of these forms that I just mentioned, which asks you to provide feedback about the program. We always welcome and value your feedback, so please take some time to complete that as well. So that's all I have, and with that said, Giza, I'm going to turn it back over to you. Thank you very much.
Thank you, John, for the partnership and for all the logistics. I also want to personally thank Cynthia as well as Alicia May, and I'm going to embarrass Alicia here, if you allow me. As my mentee, Alicia got her PhD just recently, about a week ago. So Dr. May is the one behind all of the logistics of bringing the webinar to you today, along with Cynthia. So congratulations, Alicia, from your super proud mentor. And thank you so much, Cynthia, for the partnership in this. All right, it is now my pleasure to welcome today's moderator, Amanda Oren. Amanda began her professional career advocating for children with autism who had been denied a meaningful education under the Individuals with Disabilities Education Act, IDEA. She has a stellar bio, which I think Nick will be putting in the chat momentarily, but I want to say that she was also a public defender in both criminal and family court. And currently, she is a supervising attorney of the Children's Services Unit in the Monroe County's Law Department here in New York, which provides legal representation for child protective services. Amanda and I had the pleasure of working together at ILS and helping implement the Harrell Herring settlement. So I think one of the bright spots is that we got to work together previously and again today. Amanda will be facilitating the conversation with our speaker today. We're so excited to have Kai-Lin Shu. Kai-Lin has been an attorney at the Legal Aid Society Juvenile Rights Practice since 2002, where she provides education advocacy to clients, ensuring that they receive the general and special education services to which they are entitled, and defending them in school disciplinary matters. She has stellar titles as well, and amazing training, and Nick, again, will be putting her full bio in chat. Kai-Lin, thank you so much for joining us today. I'm passing the virtual floor to you.
Thank you so much for having me, and thank you so much to everyone who is attending this training today on special education advocacy for justice-involved youth. I'm the assistant attorney in charge at the Catherine A. McDonald Education Advocacy Project, which is part of the Legal Aid Society's juvenile rights practice. Legal Aid is the largest provider of legal services for the indigent in New York City. We have multiple practices, including the juvenile rights practice, which represents 90% of children in the New York City family courts on child protective, delinquency, and PINS cases. Our colleagues at JRP identify cases that need education advocacy, whether it's general education, special education, or school discipline issues, and that's how EAP gets involved. We'd like to launch our first poll at this time. We'd love to know what role everyone plays in working with justice-involved youth. So I'm seeing about 50% are attorneys, but we also have probation officers here, social workers, caseworkers, educators, and others. I'd be interested to know what your roles are. If you could put it in the chat, that would be great. Okay. So we're going to move into the presentation. Here's the outline for today. I just want to sort of give the caveat at the beginning that it's a lot of information and it's very, very dense. So, you know, don't feel like you have to sort of learn it as you go. There are a lot of things that I'm still learning on a daily basis, having done this for over 20 years. So the material will be provided to you if it hasn't already. So I want to start out by talking about justice-involved youth. As all of us know from our work with justice-involved youth, they are among the most vulnerable of populations. They are overwhelmingly and disproportionately poor. They are predominantly Black and Latino. In New York State, 67% of children who are incarcerated are Black and Latino, although they make up just 43% of the population. And the statistics on how many of them have disabilities is quite staggering. Over 30% of incarcerated youth are identified as having a disability under the IDEA, the federal law which governs special education, compared to just 10% of the general population. Some estimate that as much as 70% of youth who enter the justice system have a mental health, sensory, or learning disability. And often these youth have not yet been evaluated or identified as a student with a disability when they enter the justice system. So the overrepresentation of youth with developmental disabilities in the justice system can be attributed to several reasons, and this was highlighted in a 2021 article titled "The School to Prison Pipeline for Probation Youth with Special Education Needs" by Kim Johnson, Reinhart, Logan Green, Lamelli, and Nurius. The first is school failure, academic struggles, inadequate services, and exclusionary discipline. And when I talk about exclusionary discipline, it includes everything from a formal suspension, which triggers a due process suspension hearing, to something seemingly as innocuous as calling the parent to pick up a child early from school or sending them to the principal's office due to their behavior. Anything that excludes a child from their educational setting can be considered exclusionary discipline. 2, susceptibility. Children with developmental disabilities often have characteristics, including but not limited to low impulse control, irritability, and poor problem-solving skills, which can contribute to their participation in the justice system. And then finally, differential treatment. Youth with developmental delays often experience more punitive treatment in schools and in the justice system. So what are the legal protections available for children with disabilities? Unfortunately, those protections are quite robust. There are federal protections, so the IDEA, as well as Section 504 and the ADA, and I'll go through these in greater detail. In New York State, there are the Part 200 regulations of the Commissioner of Education, which are New York State's policies and procedures that comply with federal requirements. There's also Article 89 of the New York State Education Law, sections 4401 through 4410. You may have local regulations. So for example, in New York City where I practice, we have the regulations of the chancellor, as well as the New York City Department of Education's Special Education Standard Operating Procedures Manual that we use to advocate for our clients. And again, your locality may have similar regulations in place as well. Finally, there are school-based rules, policies, and procedures at times. Private, parochial, and charter schools may have their own policies and procedures that are supposed to comply with federal and state law, but often sort of do take liberties at times. So the first federal law that I want to talk about is the IDEA, or the Individuals with Disabilities Education Act. It started out as the Education for All Handicapped Children Act, EHA, from 1975 to 1990. In 1990, Congress changed the title of the EHA to the IDEA, as it is now known, and it was reauthorized in 2004 and amended in 2015. And I took out this quote because it sort of exemplifies the vision of those that developed the IDEA, which says that disability is a natural part of the human experience and in no way diminishes the right of individuals to participate in or contribute to society. Improving educational results for children with disabilities is an essential element of our national policy of ensuring equality of opportunity, full participation, independent living, and economic self-sufficiency for individuals with disabilities. So what is it that the IDEA does? The IDEA provides federal funds to state and local education agencies for the education of students with disabilities birth to 21. It lays out the process and timelines for special education evaluations, consent, and developing special education plans. And it also provides protections for students with disabilities who are facing school disciplinary matters. There are several sort of main tenets of the IDEA that you will hear when talking about special education. So the first is LRE, or least restrictive environment. And what LRE means is that a student with disabilities will, as much as possible, be exposed to and educated alongside their peers who do not have disabilities or who are typically developing. In other words, with LRE, we don't want children with disabilities to be segregated or isolated if at all possible. 2, free and appropriate public education, or FAPE, which I'll explain in greater detail in a later slide. And then 3 is child find. States are required to have policies and procedures in place to ensure that children with disabilities are identified, located, and evaluated. Oftentimes schools are the best place for children to be identified because the educators working with them may notice that they are falling behind in class or are exhibiting behavior issues, or there's something that's interfering with their ability to learn. So we are responsible to identify those children. The second sort of federal law that protects children with disabilities is called Section 504 of the Rehabilitation Act of 1973. And it is one of the first federal civil rights laws which provide protections to people with disabilities. It protects the rights of individuals with disabilities in programs and activities that receive federal funding from the United States Department of Education. It allows for the creation of a 504 plan for students who need one. And similarly to the IDEA, it provides protections for students with disabilities facing school discipline. So I mentioned earlier that FAPE is one of the main tenets of the IDEA, and it also is part of the 504, Section 504 as well. And what a free and appropriate public education is free at no cost to the parent, appropriate. The program must be reasonably calculated to enable the child to receive educational benefits. Public, it must offer the same access to public schools as students without disabilities, although sometimes private agencies provide the services through public funding. And then education, it must be specially designed instruction that is designed to meet the unique needs of students with disabilities. Finally, we have the federal ADA, or the Americans with Disabilities Act of 1990, which is a civil rights law that provides protection from discrimination to Americans with disabilities and requires employers to provide reasonable accommodations to employees with disabilities. Title II of the ADA, which prohibits discrimination by state and local governments, applies to nearly all public and private schools, except for some religious schools. Schools may not discriminate against students with disabilities and must offer reasonable accommodations. So if a school or a school district is violating the ADA, your remedy would be a complaint to the Office of Civil Rights. You also have a right of action in federal court to demand corrective action and even damages. But I'm really talking more today about the special education process under both IDEA and 504. As those are the laws that allows us as advocates to develop plans to help the youth we work with in school. So this is an outline of the special education process. You'll see that it starts with referral, then goes to consent for evaluations, the IEP meeting, consent for services, and then implementation. And this is all laid out by the IDEA and also in the Part 200 regulations in New York State. And you can see that the process includes two distinct points at which consent is required, both prior to evaluations and prior to implementation. And that's just something important to keep in mind. So as I discuss the steps of the special education process, I've provided the sites to the New York State Part 200 regulations that govern. The first step in the special education process is the referral. So a referral must be made when a child needs to be evaluated for special education services. It must be in writing, and it must specify concerns about the child's development. So for example, if you have a child that you are concerned has speech delay, you would want to specify that in the referral form and perhaps request a speech and language evaluation. If the child has a behavior issue, you would want to specify that in the referral so that the child potentially could receive either a psychiatric or psychological evaluation. The referral must also include the parent contact information. This is because, again, the district will need to get parental consent at 2 stages. The referral can be made either by the parent or the school district. What we find in New York City is that the school district rarely makes the referral. It's often left to the parent. Other professionals, such as those of us who work with justice-involved youth, can request that the student be referred, but that is distinguished from an actual referral. Like, we cannot actually make the referral. It has to be the parent. But judges, doctors, professional staff members of a public agency with a responsibility for the welfare, health, or education of children, we can all request that the student be referred. And oftentimes, for me as an education advocate, I'm working with the parent to facilitate the referral, ghostwriting their referral letter if that's something that they've asked for assistance with, to ensure that an appropriate referral is made. And then once you've drafted the referral, it should be sent to the principal of the school that the child attends or to the chairperson of the district where the child resides. And often I'm copying both just to cover all my bases. So once a referral is made, the district has 10 school days to notify a parent to refer the student or obtain parental consent for evaluation. So let's say they've heard from a doctor that a child might need a referral. They have 10 school days to reach out to the parent to ask the parent to actually refer the child. Or if the parent has already made the referral, they have the 10 school days to obtain parental consent for evaluations. So the referral alone does not equate to consenting for evaluations. It's a separate step. The date of receipt of referral means that someone in the district has received the referral. So oftentimes, if I'm submitting a referral, I'm going to want to confirm with the person that they've actually received it, because that starts the clock There are time limits on, when the school districts are supposed to conduct all of these things. And there are remedies if they don't comply with the timelines. The parent and district can agree to withdraw the referral. Sometimes a parent might think, oh, my child needs to be evaluated for special education, when actually the school is able to offer, additional services and supports that don't actually require the child to be classified as a special education student. So within 10 school days of receipt of the referral, the school can hold a meeting with the parent to see what other supports and services can be provided in the general education setting. So as I mentioned earlier, consent is required before evaluation, and consent is required from the parent. The parent is defined in the Part 200 regulations, and the birth or adoptive parent is always presumed to be the parent. In some situations, legally appointed guardians, persons in parental relationships, or individuals designated as a person in a parental relationship, or a surrogate parent can also consent. The foster parent can act as a parent unless prohibited by law, if the parent's rights are terminated, or if the foster parent is otherwise appointed as a surrogate parent. So as you can see, the biological parent's rights would need to be terminated, as one of the conditions for a foster parent to act as a parent. So presumptively, it's always the birth or adoptive parent, even if the child is in foster care. And a surrogate parent can only be appointed when a parent's identity or whereabouts are unknown. So that's a pretty restrictive condition, right? You would need a parent who has been missing for many, many months, where nobody can reach them by phone. They have not shown up to court. They have not been at their last known address. There are sort of multiple levels of review before you can deem that a parent's identity and whereabouts are unknown. So in the definition of a parent in the Part 200 regs, it clearly states that a public agency that provides education or care for the student, or a private agency that contracts with a public agency for such purposes, shall not act as the parent. What does this mean practically? It means that foster care caseworkers, probation officers, and school staff cannot act as a parent for consent purposes. So sort of as a practice tip, what do I do if the parent doesn't agree to refer a child for evaluation, refuses to consent for evaluations, or later refuses to consent for services? When we're working with justice-involved youth, I think we have to recognize that their parents may already be feeling defensive, vulnerable, and powerless. And that is compounded when you are saying that their child may have a disability. So helping the parent to recognize that they have control as the education decision maker for their child, particularly for special education purposes, can actually be empowering and motivating. So explaining to a parent what their rights are in the process can actually help a parent see that, they are empowered and they should be participating in this process. So one of the first things you can do is explain to the parent that their consent for special education can be withdrawn at any time, including even after services have been implemented. So just because a special education is developed for a child doesn't mean that that has to be forever. Second, often as advocates, we are arranging for a meeting between the family and the school and other relevant parties to explain why services might be beneficial for a child. You'll be surprised at how many times, a parent is told your child needs a special education evaluation, and no one has explained what the school's concerns are or what other people's concerns are about the child that is leading them to believe that, and what services might be available to the child. No one has explained anything about the process to them. And so, of course, a parent not knowing, not having information might just say no. And then finally, although we don't recommend this, due process proceedings can be initiated by the school if a parent refuses to consent for evaluations, but not if they refuse to consent to initial services. So if a parent, does not want to consent to evaluations, the school can file a due process proceeding, but they cannot file a due process proceeding to force the consent to services. what are the evaluations that are required as part of the special education process? So first, physical exam. It is something that the family is asked to provide to the school and not something that the school does. It is, basically a checkup by a doctor to identify or rule out any physical issues that may be impeding the student's learning, such as maybe vision or hearing impairment. Second, there is a psychological evaluation, which will include IQ testing and academic testing. IQ testing measures a child's cognitive potential, while academic testing tells us where the child is academically in terms of grade level equivalencies in math and reading. There is a social history where a social worker will interview the parent to talk to them about the child's developmental milestones, the family history, family background, any history of developmental delay in the family, things like that. An observation in a classroom or an environment appropriate to the student's age if the child is not yet in school or not attending school. And then other evaluations can be requested. They include a functional behavioral assessment where a behavior is impeding learning. So the functional behavioral assessment measures the ABCs of a child's behavior. The A stands for antecedent. What is triggering the child to behave in a certain way? The B stands for behavior. And then the C stands for consequence. What is the child getting out of behaving in a certain way? Perhaps they are acting up during math class, because when they do act up, they get sent to their counselor's office, and they don't have to do math, which is very hard for them. So by, assessing, by conducting data, collecting data, and doing a functional behavioral assessment, the school can then use that to develop what's called a behavior intervention plan, or a plan to address behaviors even before they occur. You could also ask for evaluations such as a speech evaluation if there are speech concerns, an occupational therapy evaluation if there are fine motor concerns. Fine motor relates to things like eating, writing with a pencil, and then physical therapy, which is gross motor, so walking upstairs, pushing open a door, things like that. Evaluations typically take place at the school or at the district office. Some evaluations may be conducted by agencies that are contracted by the district. They must be conducted by trained and knowledgeable personnel. They must be free. They must be provided in the student's native language. And the written evaluations must be provided to the parent in their native language or mode of communication. A parent can bring in evaluations conducted outside of the school district, such as a psychiatric or other mental health evaluation or a neuropsychological evaluation, which they can share with the district for consideration, especially if it has information that is different from or supplemental to what the school district has found in their evaluations. If the parent disagrees with the findings of the school district evaluation, they can request what's called an independent education evaluation or an IEE at the district's expense, and the district is supposed to provide it without unnecessary or unreasonable delay. So at this point, I'm going to launch our second poll. To ask how many of you have ever participated in an IEP meeting. Oh, so it looks like many of you have. That's wonderful. It's looking like around over 60% of you have participated in an IEP meeting before. That's great. Yeah, we landed at 64% yes, 36% no. So the IEP stands for Individualized Education Plan, and it is the contract between the school district and the family regarding the special education services the child will receive. So the IEP meeting is held by the IEP team, and during the meeting, they conduct a review of the evaluations, a review of how the student is doing in their current educational placement. They determine whether a student is eligible for services, and if found eligible, they make recommendations and develop the IEP. The IEP team can be called either the Committee on Preschool Special Education for children 3 to 5, or the Committee on Special Education for children 5 to 21. The members include the parent or parents, general education teacher, the special education teacher, school psychologist, district representative, a parent member who is a parent with a child who receives special education in that same school district. A physician can attend if requested by the school or parent, and quote, such other persons having knowledge or special expertise regarding the student. So that's how those of us who are education advocates and attorneys can get into the IEP meeting, assuming we have the consent of the parent to be there. If the parent objects to our being there, we cannot be there. And I have definitely been kicked out of an IEP meeting before. Okay, so IEP eligibility. A child will not be found eligible for services if there has been a lack of appropriate instruction in reading, there has been a lack of appropriate instruction in math, or the child has limited English proficiency. So what does a lack of appropriate instruction mean? Often school districts will consider factors such as lack of exposure. Perhaps the child has never attended school before. Perhaps in the child's country of origin, schooling was sporadic, or they did not attend, or they stopped attending after a certain time. Excessive absences can be considered. If a child has had multiple moves, which sort of interrupted their education, that can be considered. Having been homeschooled could also be another factor. In other words, the school district is not going to want to find a child eligible for services if the reason that the child is behind may not be related to a specific learning issue that the child has. However, we need to remember that these factors are not mutually exclusive, right? A child could have experienced a lack of appropriate instruction. They could have had excessive absences, but still also have a disability. So I think, as education advocates, that's something we want to sort of parse out and push for if the school district is trying to deny services. What are the recommendations that can be made on an IEP? So New York State has 13 disability classifications that are put in an IEP for school-age children 5 and up. For preschool children, they just have a general category called preschool student with a disability, and they don't get more specific. But for school-age children, disability classifications include classifications such as autism, speech impairment, learning disability, intellectual disability, emotional disability, and several more. They can make the program recommendations. So what class size and ratio will the child have? What is their school setting going to be? What supplementary aids and services will the child need in school? Will they need occupational therapy, physical therapy, speech, counseling? Will they need a one-to-one paraprofessional in school? The IEP will also recommend annual goals and short-term objectives so that we can actually measure the child's progress, IEP progress. It will include testing accommodations if the child needs them, particularly for 3rd grade and up, where state testing kicks in at 3rd grade. So is the child going to need extra time on their test? Do they need directions read aloud to them? Do they need to take the test in a separate location, or maybe they need breaks? The IEP will also indicate promotion criteria and whether or not the child is standardized or alternate assessment. So standardized assessment means that a child is expected to take all standardized exams taken by non-disabled children, including the New York State exams and the Regents exams. Alternate assessment means that it is a category for students with severe cognitive disabilities who are exempt from standardized exams, and other measures are used to measure progress. Other mandates on the IEP might include things like specialized transportation, extended school year, and then for youth 15 and up or younger, if appropriate, transition services. So for example, as the child is getting older, when they leave the public school system, what is the plan for transition? What are their goals? Do they need things like travel training, as they're becoming more independent? Those are factors you can consider in the IEP as well. So the IEP and special education allows for a continuum of services. Remember LRE, so least to most restrictive. So the least restrictive would be that the child remains in general education, but receives services and supports. Perhaps they just needed physical therapy or speech therapy. And so that can be added to an IEP, but the child will remain in a general education classroom. Perhaps the child needs resource room or sets. That is a special education teacher working with the student in a small group on a pull out, so taking them out of the classroom, or push in basis, pushing into a classroom, working with a small group on whatever the class is working on. Then we have integrated co-teaching, where we have a special education teacher, a general education teacher, and no more than 12 students with IEPs in the classroom. It could be a classroom of 25 to 30 students. The other students who do not have IEPs are typically developing. The teachers team teach the class. And then we have a special or self-contained classroom where all of the students in the classroom have IEPs. The most students allowed is 15 for high school and 12 for elementary and middle school. In New York City, we have a district called District 75. I believe it's called BOCES in other districts. So that is a school district where all of the students have IEPs and receive special education services. So it's considered extremely restrictive because in that school, there are no typically developing students for the students with IEPs to have exposure to. Classrooms in those settings have even smaller ratios, including 12 to 1 to 4, 8 to 1 to 1, and 6 to 1 to 1, depending on the child's needs. We have home and hospital instruction. So hospital instruction is the instruction that's provided if a child is in a hospital setting. Home instruction is typically for children who have medical needs that prevent them from attending school. And it provides 10 hours a week for elementary school students and 15 hours a week for secondary students. Then we have in or out of state private schools. There are some schools that specialize in working with children with disabilities that are contracted with New York State to provide special education services. And finally, there are private schools that specialize in working with students that are not contracted with New York State and that have incredible tuition rates, such as $190,000 a year. If a parent is interested in a school like this, they really should seek legal representation because it requires them to file a due process proceeding. And I just put the name of a case, Burlington. There are 3 prongs that a parent would need to meet in order to be awarded with tuition to a non-approved school, and they would have to prove that the school district violated FAPE, that the school that they've identified their child is appropriate, and that the equities are in their favor to determine if a parent is entitled to reimbursement or funding. But that is an entirely different, probably 2-hour training. That is for another time. So the IEP implementation of services must take place 60 school days after consent for evaluation is received. So when we're talking about 60 school days, by the time you add in, weekends and school breaks, it's really looking like 3 months after consent has been received. So it is kind of a slow process. The parent must provide consent for the IEP to be implemented. And the remedy for timeline violations would be compensatory services through a due process proceeding. So for example, let's say 60 days is, the 60-day mark is on February 1st. And yet the school district delayed and did not implement services until May 1st. then the child would be entitled to compensatory services for the period between February 1st and May 1st that they were entitled to the service, but was not receiving it. The IEP must be reviewed annually or earlier if requested by the parent or the school. And every 3 years, the school district is supposed to reevaluate the child and provide what's called a triennial. So what do you do if a youth is incarcerated? Are they still entitled to special education services? And are they still entitled to, participate in the special education process? And the answer is yes. In a memo released by New York State, the Education Department in October 2010, which is in your materials, Section 3202(7) of the Education Law and Part 118 of the Regulations of the Commissioner require the school district where the county correctional facility is located, the district of location, to provide education services to incarcerated youth. So we see, for example, in New York City, when one of our clients is incarcerated at Passages, that in fact, the New York City Department of Education is there, and they have a school psychologist on staff who is available to, conduct special education evaluations and hold IEP meetings. For a student with a disability who had an IEP that was in effect prior to placement, services must be comparable to the student's IEP, and they must be implemented until the district of location can meet to develop a new IEP for the student. Okay, so now we're going to talk about the 504 process. Section 504 eligibility is established if the child has a physical or mental impairment, disabilities, health conditions, mental disorders, learning disabilities, which can be temporary like a broken leg or episodic like asthma, and that impairment substantially limits at least one major activity, which includes everything from walking, hearing, breathing, sleeping, learning to reading. And there is a whole list of other major activities under Section 504. So a school must conduct an evaluation, regardless of whether the parent or guardian has requested the evaluation, if the school has reason to believe the student needs a special education or related service and aids due to a disability. So that is sort of what we talked about earlier in terms of the child find obligation. Now, they still can't conduct the evaluation without the parental consent, but a school is obligated to identify students who might need to be evaluated. The parent or guardian can also request the evaluation. School districts and individual schools typically have what's called a 504 coordinator who oversees the 504 process. And outside evaluations or those conducted for the IEP process can also be considered as part of the 504 process. So a 504 plan does not necessarily require a written plan, although most school districts do develop written plans. The plan is intended to provide accommodations and supports so a student can access both academic and extracurricular activities and not be excluded from them due to their disability. So the key is access. A student who has broken their leg may need access to the elevator that's reserved for faculty and staff in order for them to access their English classroom, which is on the second floor of a building. A student with diabetes may need a health paraprofessional to help them with their insulin shots to be able to access school and to be able to attend school on a regular basis. A student with a 504 plan does not necessarily need special education services and an IEP, but a student with an IEP does not need to have a 504 plan if the IEP addresses all of the relevant issues. Okay, so I'm moving on now to talk about school discipline. We're going to launch our third poll at this time. So the question in the third poll is, have you ever participated in a manifestation determination review? And it's okay if you don't know what that is, because I will be explaining what it is. Okay, so it looks like we're landing about 25% of you have participated in an MDR, which is great. And 76% have not participated in one. So this is sort of interesting in contrast to IEP participation, which was sort of reversed. So school discipline, as we know, disproportionately affects vulnerable students, including students of color and students with disabilities. And school discipline feeds what we call the school to prison pipeline. The school to prison pipeline describes the pathway in which children get pushed out of schools and funneled into the juvenile and criminal justice systems. Policing students in schools, criminalizing behavior in schools, and exacting exclusionary discipline all contribute to the pipeline. If a student is not in school, they are in the community and potentially increasing their chances of getting justice involved. So the IDEA and Section 504 both provide protections for students facing school discipline proceedings. They both require something called a manifestation determination review. So an MDR, manifestation determination review, must be held if there is a significant change in the student's school placement, a removal from class or school for 10 consecutive school days, or a series of removals that total more than 10 school days in a school year and constitute a pattern of removal. And the question that we ask at the MDR meeting is the incident leading to discipline, suspension, or expulsion a manifestation of the student's disability? Or did the school district fail to implement the student's 504 or IEP as written? And if the answer is yes to either of those questions, the student cannot be excluded on the basis of their disability and must be immediately reinstated to school. In other words, a student should not be punished and excluded from school due to their disability. So you may encounter a situation where a child has not yet been identified as a student with a disability and does not have an IEP. Even if a student has not yet been found eligible for an IEP or 504 plan, the school will be deemed to know the child has a disability if the student's parent has requested an evaluation, even if the school has not yet begun the evaluation. The student's parents have expressed concern in writing to the school that the student may need special education services, although a concern expressed orally is acceptable if the parent is not capable of expressing their concern in writing. And the student's teachers have expressed specific concerns about a pattern of behavior demonstrated by the child to supervisory staff, for example, to the principal, the director of special education, or other supervisory personnel. So in situations where a child is considered deemed to know, they are entitled to the MDR, and you can also request expedited evaluations. A student is not entitled to an MDR, even if they might be deemed to know, if the parent refused to consent to an evaluation. Let's say at some point the school said, we really think your child might benefit from special education services, and a referral was started, but the parent refused to consent to evaluations. Perhaps the district offered special education services to the child, but the parent refused. In other words, they refused to consent at the service implementation stage. Or the child was evaluated and it was determined that the student did not qualify for special education services. So unfortunately, in those situations, the child would not be entitled to an MDR. So at this time, for attorneys requesting CLE credit, a CLE verification code is now appearing. I'm also going to recite it. The code is as follows: LVPL-2019. That's L for lion, V for violet, P for paper, L for lion -2019. This code needs to be entered on the certification and evaluation form in order for you to receive CLE credit. So the final portion of my training discusses what I like to call the court to school pipeline. I did not invent that term. But you know, by the time youth are justice involved, they are already in the school to prison pipeline, but we can still try to disrupt that process. The court to school pipeline is a term coined by Professor Lisa Grummet at New York Law School, and it urges those of us working with justice involved youth to use the judicial system as a way to encourage school engagement and ensure that youth are receiving the services to which they are entitled. Although courts cannot generally direct educational services for youth, right? Courts don't have jurisdiction over school districts, but the judicial system can do things like appoint an education advocate who can help advocate for a student or order services outside of the education system. If the youth is incarcerated, obviously we don't want to encourage placement in carceral settings, but that could be an opportunity to screen a child for any learning issues at intake. In New York City, they passed a law this year requiring the Department of Corrections or the Department of Education to conduct dyslexia screenings of youth 18 to 21 in custody who self-report that they do not have a high school diploma within 72 hours and offer evidence-based interventions. And I would argue that 18 to 21 is often too late. You know, we should be doing that for our younger youth as well. We can also use child's incarceration as an opportunity to obtain comprehensive evaluations. Often our justice involved youth are very mobile and are not staying put at school, but perhaps while they're incarcerated, we can use that as an opportunity to evaluate them for special education or mental health purposes. And then finally, you know, we can use it as an opportunity to re-engage in school. Obviously, we don't want to use school attendance as a reason for placement, but sometimes it does allow a student to re-engage. So as another practice tip, what do you do if the youth needs an education advocate? If you're an attorney and you don't do education advocacy, you can seek out your colleagues who do provide education advocacy. If the child that you're working with has an attorney, you can ask that attorney if they provide education advocacy, or you can refer them to an advocate in the community. If the youth is in New York City, you can reach out to us to see if we already represent the youth in court or for a referral to another education advocacy agency. Most jurisdictions in New York State seem to have education advocates. We actually recently referred a youth who lives in Genesee County, which I did not know was distinct from Geneseo County, and I'm probably pronouncing both of those incorrectly, but to an education advocate for suspension advocacy. So I thought that was great. You know, we had a call come into our suspension hotline and somebody in Genesee County needed an advocate and we were able to refer them to someone. And then there is something called COPA, or the Council of Parent Attorneys and Advocates, who are attorneys who do disability advocacy. So you can always look at that directory to see if there are any providers who might be able to work with the youth that you work with. So that takes me to the end of my presentation. This is my contact information. Please feel free to reach out if you have questions about this presentation. I know we're going into question and answer now, so hopefully I'll be able to answer some of your questions here. And here is the second CLE code. Once again, for attorneys requesting CLE credit, please note the following CLE code, which is KLOP-1524, K Kite, L Lion, O Ocean, P Paper -1524.
Thank you, Kylan. That's a lot of great information.
So much.
I know
so
you can
sorry.
talk for hours on this.
Yes.
And just to let everybody know, in case they didn't see it in the chat, we are extending to 1:15 for question and answers. If you could stay on, if you'd like to stay on, there's several good questions we've seen in the chat. I think I want to kind of direct your attention, especially because I'm deep in the world of truancy. You know, everybody calls in CPS reports on kids not going to school. and I'm sure you see a lot of that as well. When the district uses that the child hasn't been there or they haven't received enough instruction to prevent them from being classified, how would you act, like, how would people push back against that? I'm assuming it's a school determination, and how do you push
Right.
back?
I mean, one of the ways we've pushed back is to say, well, what have you as a school district done to try to engage the student, right? Because they can always say, oh, attendance is an issue, but have they reached out to the parent? Have they made efforts to sort of determine what the barriers are for the student? Because maybe it's something the school could help resolve, right? So I think pushing back is the answer. And, you know, the majority of the time, if a child is experiencing delays, I understand that you don't want to classify a student who does not have a disability, but there are so many benefits to having that sort of classification and services. So we definitely want to push where we can.
Thank you. Sorry, I'm having trouble unmuting. Someone asked a question along those lines. Can a district use can they use excessive absences to declassify a student if a child already has an IEP?
No. Declassification could only happen if a child is either found by their teachers to no longer need services, but there would also have to be evaluations and testing done to ensure that the child has achieved their IEP goals and no longer needs to be classified.
I guess another question on the manifestation determination review. Someone put a good point in here, and I've actually seen it as well, where school districts just send kids home. They call the parent instead of actually suspending them. I don't know if you want to talk a little bit about that.
Yeah, I mean, they do that all the time. It's exclusionary discipline, you know, and I think knowing that an MDR is required, even when there is a pattern of removal. So it doesn't have to be a formal suspension, which says, you know, you're going to be out of school for over 10 days, right? The MDR is allowed to occur if the child has been out 2 days in September, and then 3 days in October, you know, 4 days. And if those sort of days out add up, you know, I sort of the best way to do it is, I think, to keep track, you know, encourage the parents that we're working with and all of us as advocates, you know, keep track of a calendar of days that the student is out and missing instruction, you know, not getting their special education instruction that they're entitled to. And once they reach 10 days, I think it's totally fair for you to go back to the school to say, hey, we need to have an MDR. The child really should not be excluded from education any further, you know, following this meeting, of course, and determination. And, you know, I have to say, MDRs are often very difficult to win. We were losing them for a very long time. And I think part of it is sort of forcing school districts to do them, because the more they're required to do them, the more they learn what it is that goes into an MDR. And we are finding that New York City has become a little bit better, I think, because advocates keep pushing for these meetings and participating in these meetings and advocating for clients at these meetings. So encouraging school districts to do them, I think, gives them the practice to do so.
And can that request, does it have to come from the parent, or can an advocate do it on behalf? Could an attorney do it on behalf of their student?
Yes, I think you can request on behalf. I mean, realistically, the school district is supposed to let you know when the child is entitled to the MDR. So hopefully they already are doing that, but if not, certainly advocates can ask on behalf of parents and the youth that we're working with.
And I see the question in here about if a child is held in a secure facility, I mean, who is responsible for providing that special education service?
So that would be the school district of location where that carceral facility is located. Okay.
So I know you were talking a little bit about that previously. And then in your note, it said until the school district from where they came could hold.
Until the school district of location can hold their own IEP meeting.
Okay.
Yes, yes.
There was a question in here about a child. what do you do when you have a district who is providing, like an under-resourced school district, who is providing some services? It may just be close to the line, but maybe not enough for this really, for the child to benefit. And so they're kind of still setting them up to fail. Is there an avenue to push back, or is that some other procedure?
I think, I guess my question would be, is that in the context of the child already having an IEP or the child not having an IEP and needing one? But if the child doesn't have an IEP, you know, I would push for the evaluation. And if the school district doesn't agree to the evaluation, you can see if there are other mechanisms to try to get outside evaluations as well. And there are some pro bono providers of these evaluations. They can be very, very expensive. But you know, occasionally a hospital in a big city may have a special education unit that will be able to provide evaluations on a pro bono basis. An agency such as AHRC might be able to provide a psychological evaluation through insurance. If a child has an IEP and goals aren't being met, I think that's the greatest way to sort of advocate for services. You know, if you're saying that the child is sort of on the cusp of not doing well, and the school is just providing the minimum, you know, what you can point to are the goals, right? Did the child achieve the goals that the school district set out for that child in the IEP? That's sort of the best way. But if, for example, a child is promotion in doubt, that's another way to say to the school district, well, you're providing these services, but you're also saying that the child might not get promoted. So, you know, what is it that you're doing that's allowing the student to move forward?
I wanted to ask, kind of backing up a little bit, a more general question, I guess, about, it's more of a philosophy of, some people use the judicial system as a tool about, you know, to address youth issues. And is that effective? Does it backfire? What is your experience generally?
I think it can be both. You know, do I think sometimes it backfires? You know, do I think the judicial system always needs to be involved? Not necessarily. But do I think that, you know, sometimes it provides a great opportunity to intervene? Yes. You know, we've seen clients who sort of, you know, were able to utilize the system to get what they needed, right? Not just while they were in the system, but afterwards. And we've seen others, you know, who unfortunately the system was used against. But I think, you know, the hope is that as education advocates, we at least know sort of what the rights of youth are, so that we can advocate where we feel it would make a difference.
There's a specific question here where someone asked, they have a child who's basically on a wait list for a BOCES program. And so the child's only getting the 15 hours of instruction a week. Do you have any advice on kind of how to advance that case?
We run into that situation also, unfortunately, you know, and that's one of sort of the major negatives, right, of special education, is the dearth of available services everywhere. And I think, you know, particularly post-COVID, we're seeing a dearth of service providers and people not going into, you know, those professions. So the only advice I can give is just continue being, you know, a thorn in the side of the school district to try to push that student's, you know, place on the wait list. But it's very, very challenging when there are no seats.
One question the YJ wanted me to pose is, how do court personnel, kind of, who is this? How can they help mitigate exclusionary discipline practices experienced by youth in the system with disabilities?
I mean, I think one way is to make sure that the child has appropriate evaluations and has an appropriate IEP that addresses behavior. Like I mentioned before, you know, there's a mechanism for assessing what a child's needs are when their behavior is interfering with their learning. And oftentimes we'll go to an IEP meeting or a school meeting where the child, you know, the school is going on and on about all the terrible things the child does. And you say, well, have you done a functional behavioral assessment? And they look at you and they're like, no. And you're like, well, why not? You're the one telling me that this child is misbehaving and doing all these terrible things and, you know, disrupting the classroom. And yet you haven't collected the data to help that child by developing a behavior intervention plan. So I think that is one way, sort of ensuring that the child has appropriate evaluations and services in place. And then, again, advocating at the MDR, I think, is another way. Also, you may want to consider too, is the child in an appropriate placement? Maybe they're not, maybe that's another consideration that you have to make in terms of the IEP and placement, right? If the child is constantly getting into trouble and, being excluded, perhaps we need to sort of have a larger reconsideration about perhaps they need a more restrictive setting given their behaviors. I think also one thing we don't look at enough is what are the child's mental health needs. Often when we're working with the vulnerable populations that we work with, they have tremendously high ACEs scores. They are suffering from depression, which often exhibits symptomatically like ADHD in children. So we really want to figure out what it is that's causing the behavior, whether it's external or internal, so that we can address it appropriately.
I have I guess a follow-up to a previous question I had asked. I think I didn't read this completely. If a child is placed, for example, in another county, is it then that school district where that facility is located then at that point as well, even though it's maybe not a secure detention?
Yes. So it's the school district of location of the carceral facility that is responsible for the education.
There was a question about as well, when a child is also in the child welfare system as well as the juvenile justice system, how does that, if a parent wants to terminate their consent to an IEP, but the child is also involved with ACS, CPS, and the rest of the state, how does that play out?
So it's the parent's right to terminate services, to withdraw consent, to not consent to services. I would say that, oftentimes as attorneys, as advocates, our role is also to mediate and to negotiate. So, we should bring those skills to the table to work with parents. We get cases referred to us a lot where people are telling us, oh, the parent isn't cooperating, the parent is refusing, the parent is doing this, that. But when we get permission from the parent's attorney to engage with the parent, to talk to the parent, maybe with the parent's attorney, a lot of times, their sort of refusal is because of their lack of information and their lack of feeling like they have any power over the process. And I think that is especially true for children who are in child protective situations, have been removed from their parents. I mean, what is more powerless as a parent than losing your child, right? And having your child placed elsewhere, and then being told your child may have a disability. So you're going to wield your power where you can, which is to say, you know what, you want my child evaluated? No. So I think that, instead of viewing it in this contentious or antagonistic way, we need to see that the parent is part of this process, a really important part of the process, and to include them and to make them feel engaged and empowered. The other thing I wanted to bring up is that, a lot of times the parents that we've worked with have had their own experiences in special education and do not necessarily feel like they've benefited, from the special education services that they received through their school district. So it's just another, aspect to keep in mind.
You had mentioned, and someone asked a question related to this, you had mentioned the court can order other services. Can you talk about kind of what that would be generally, or you have some specifics you could advise people to ask for or know what to ask for?
Sure. So for example, perhaps the court could order outside evaluations, right? That might assess the same things that the school district would assess. Perhaps they can order mental health evaluations. Perhaps they can order tutoring to be provided. I don't know, I'm just thinking about all of the things that, since the court system does not have jurisdiction over the Department of Education, what are other ways that we can try to create the supports that might be available to the child externally, outside of the Department of Education system?
And I think this is our last question. I think you may have answered this earlier, but I'm going to ask it again just in case it's a different take. How do you push forward an evaluation for the youth who do attend school regularly? And I know you touched on it. We were talking about the determination.
Yeah. That requires a lot of negotiation. We've certainly had, youth that we've worked with who don't attend school. So sometimes what I'll do is to say to the school district, okay, give me a date and time that you are willing to do the evaluation. And, perhaps we on our end as advocates for the youth are able to convince the youth, look, I'm not asking you to go to school every day, but I'm asking you to come to this one meeting at this one time. You just can go in, get evaluated and leave. Or perhaps we offer to do the evaluations outside of the school building, right? Maybe at the district office, because I think, for a student who's not attending school, sometimes there's so many reasons that's happening, right? So it could be bullying, it could be just beef with other students, it could be that they're embarrassed after having not gone to school for 6 months to suddenly show up and get asked all these questions. So maybe the resistance is to actually physically being in that school building. But if we really want the child assessed, perhaps we can offer an alternative location. Perhaps we can say, let's meet at the community library. And obviously some school districts are going to be more flexible and willing to do this than others, but it can't hurt to try and ask.
Thank you, Kylan. This is amazing. I know it's a discussion we can have for hours, and hopefully it helped everybody watching get a little bit, some nuggets they can take away for their practice. And I think I will turn it back over to Giselle Lopez.
Thank you so much, Amanda and Kylan. This was amazing. And thanks to everybody who's been chiming in on the chat. I want to invite Alicia to do the closing remarks here for us. Thanks again. Alicia, you're up.
All right, thank you. And yes, Giza, I was suitably embarrassed earlier. But Kylan, Amanda, I also want to thank you on behalf of the YGI and everybody in attendance today for taking the time to share this important information with us. Kylan, I do want to pass it back to you if you have any last thoughts that you want to share.
So I just wanted to say thank you so much to all of you who've attended today. I hope that I've provided you with some information to enable you to consider and advocate for the special education rights of the justice-involved youth that we all work with. Thank you so much.
Great, thank you again. So in a moment here, we're launching a poll for those of you who are still in the audience, asking you how much you agree or disagree with the statements. This webinar was informative and this webinar was engaging. Please answer these questions so we know how the webinar went for you. And while everybody's answering that question, I have a couple of announcements and items to put on everyone's radar. The next YGI Lunch and Learn webinar session will be held on June 20th at noon with Dr. Shelley Craig and Dr. Ashley Austin. The pair will be presenting about their research on the Affirm Caregiver Program, which is a model that supports wellness for LGBTQ youth and their families. The link to register should be in chat now. Immediately following today's webinar, a survey should appear in the browser window that you used to join today's webinar. Please complete the survey as it allows you to provide further feedback and questions for us. This information is also used to improve future webinar sessions. The survey should take no longer than 5 minutes, and we will also put the link for the survey in the chat now. Just a reminder, the views expressed here are those of the presenter and do not necessarily reflect the views of the New York State Youth Justice Institute. In closing, I want to thank you all again for taking part in this session of the YGI Lunch and Learn series, our first Lunch and Learn Plus. We hope that you've gained something from this webinar and that you'll continue to think about what Kylan and Amanda discussed today. We look forward to seeing you at future YGI events. Thank you.